right. Hello, everybody. Welcome to our webinar. This is actually I'm calling it a surprise webinar because there was a certain sequence of events that happened last Friday that caused us to create a new episode early. So before we start getting into everything here, I'm just going to go through some quick housekeeping items. We've got a packed agenda, and then we're going to move right into introductions and into our content here. So for housekeeping items, in the upper right-hand corner, you're going to see a chat icon and a question icon. We do encourage you to leave comments as well as ask questions throughout the webinar. We will do our best to get through them as much as we can. It is a jam-packed session, so we may not be able to get to all the questions that you put in. And in addition to that, on the right-hand side, you will see some polls that we will do throughout the webinar. Lastly, when this webinar is finished, we will be sending out a recording the following morning. So let's go through some introductions here. So my name is Michael Peranto. I'm the GM of Financial Services here at Active Prospect. I will be the moderator. I've been in financial services for about 13 years, and I'm really happy to be here. So I'll go ahead and move it over to Steve.
Hey guys, I'm Steve Rafferty. I'm the founder and CEO of Active Prospect.
Great. And Aaron?
Hello, I'm Aaron Perry. I'm an attorney here at McMurray & Schuster, focusing on regulatory compliance and defense, especially telemarketing and data privacy.
And Alexandra?
Hi, I'm Alexandra Krasovic. I'm a partner at Manat. I am primarily a TCPA attorney. I've been doing this for over a decade, and I've been up and down on the roller coaster that all of you have been experiencing really over the last week in particular. So looking forward to discussing with everybody.
And Chris.
Hi, I'm Chris Dethridge, General Counsel for Apollo Interactive, a digital marketing company, typical spiel, leads, clicks, calls.
All right. Well, thank you, Chris. And thank you, everybody, for those introductions. Now, like I said, we have a jam-packed agenda today. We've got lots of questions. We're going to have some great content here. So first off, I think everybody here knows last Friday there was quite a few interesting updates that came through. We had the FCC order that initially delayed the one-to-one consent component for the TCPA. And then it was pretty much immediately, I think it was 15 minutes or an hour later, the 11th Circuit Court actually vacated the FCC's one-to-one consent rule. I think that was something that really, they waited to the 11th hour, but look, it came through and now we are here where we are today. So there's a lot to unpack here. And fortunately, we have a great panel of experts here that are going to be able to go through some questions that we all have. So before we get started, we do have our first poll here. We just want to get a good understanding of where you are in regards to the FCC's one-to-one consent ruling that happened last Friday. So off to the right, if you could go through and answer that, give you just a couple of seconds. It is an interactive poll, so we can actually see what those answers are. And we'll talk about it for real quick. All right. Give you just a few more seconds. Okay, so looking at the poll results that we see here, it looks like a decent amount of the people in our audience, almost 50%, have actually read the IMC's court's opinions and the FCC's order. We've got 36% that have heard some things, but there's still some clarity that they're looking for. And then lastly, there's about 9 or 10% that are looking really to be brought up to speed completely. So I hope that this webinar is going to help you with that. So let's just get started with the first question here. Can you all share your thoughts on the IMC case and the FCC's delay of the one-to-one consent rule? And also, what remains of the FCC's one-to-one consent rule and the TCPA after these developments? So, Aaron, can you just go ahead and start and just kind of summarize things here?
Yeah, so starting with what did the 11th Circuit rule? Well, they ruled that the FCC impermissibly tried to fill the gaps of the plain meaning of prior express consent under the TCPA. And they got to that rationale by examining the fact that the statute calls for prior express consent. They don't define prior express consent, though. So they then kicked it to common law. What does common law require for prior express consent then? And the court kind of came to the conclusion that common law requirements mean that consent is clear and unmistakable. So I think this is a larger part of the weakening of the administrative agency powers. We saw, a couple of huge administrative cases in the Supreme Court last year, and I think this is a continuation of those. Those two cases are the Loper Bright that overturned Chevron and the Corner Post that extended the timeline for injured parties to appeal agency rulings. So I think it's a continuation of the hammer on the administrative state.
Great. And Alexandra or Chris, you got any comments on that? We'll start with Alexandra.
Sure. Yeah. I mean, so just, backing up here, I think for the folks who are not necessarily following, the bouncing ball, what happened is the FCC issued a 1-to-1 consent order last year really a year to almost 2 years ago, according to the years, right? So December 2023, saying you needed to obtain consent on a per seller basis that is logically and topically related to the calls that are going to be made. IMC filed a comment in that rulemaking process. And when the order came out, then IMC used the procedures that are allowed for under the Hobbs Act to seek review of that ruling, which is how the 11th Circuit ended up deciding this IMC case. Throughout the course of last year, there were several requests at the 11th Circuit and the FCC to stay that order while the IMC decision was pending until it was decided, and those requests were not granted. On the eve of this new rule going into effect, which would have been this Monday, the 27th, the FCC finally decided that under the APA, justice would require them to stay the rule until the IMC ruling came out. Now, IMC ruling came out same day, which is why we're all having a discussion about what did it do. The ultimate result of that ruling is that the 1-to-1 consent rule is vacated. The entire section of the FCC order that relates to, the lead generator loophole, which is what the FCC called it, is gone. That means 1-to-1 seller specific consent is no longer a requirement. It means that logically and topically related is not a requirement as the FCC was applying it. So then to the question about kind of what does that mean? Well, what it means going forward is we are reverted to a world in which the 1-to-1 consent order never occurred. So that means that we look at the definition of prior express written consent as it existed before the 1-to-1 consent changes went into effect. So just for anyone who tries to just look up the rule today, there are some places where you're going to find the rule don't even reflect the current state. Okay. They still have seller specific requirements. They still have logically and topically related requirements. So you want to be cautious that you're following the proper rule. I know later we'll get into kind of what does this look like, but I just wanted to follow the path here so everyone understands. Basically, we are in a world where 1-to-1 consent order never occurred. That's where we are today.
Great.
Yeah, so it's sort of like if you haven't been paying attention to what's going on for the last year, nothing's changed. Right?
Chris, what are your thoughts on this?
I think Aaron and Alexandra covered it perfectly. So I'm just going to shamelessly plug the IMC here. The IMC is the Insurance Marketing Coalition. It's a trade group of lead generators, marketers, and also insurance providers. We meet just about every Wednesday to discuss issues in the industry, industry initiatives, compliance, all those types of things. You can join, I think, temporarily as a guest to see if you're a good fit. If you are, then you can look into joining as a full member. If you have any more questions or you want to look into joining more, you can look into the IMC at imcorg.com. That's imcorg.com.
Great. All right. So let's move into our next question here. And there's actually some great comments that are currently in the chat. A lot of these we were actually going to cover. So this question, we're going to start off with Alexandra. So Alexandra, when I read the 11th Circuit's opinion, there were really multiple instances where the court mentioned that express consent is consent that is clearly and unmistakably stated. So can you talk a bit more about this? And do you believe this will affect maybe some downstream rulings related to like a hyperlinked partner list on a lead form that we see very commonly today?
So to set the floor for what that clearly and unmistakably stated really stems from, when the court was looking at IMC's challenge to the rule, one of the things it was looking at was whether the FCC had acted within the scope of its statutorily provided authority in implementing the regulations that it did. And what the court found is that it did not. It actually exceeded the scope of that authority, because instead of implementing, which is basically bringing into effect by kind of maybe clarifying or providing further color on terms or phrases that are within the statute, it added requirements to the term that kind of made it go beyond what Congress envisioned for the TCPA. And so the term that the IMC court, the 11th Circuit, was looking at is prior express consent, which, for those of you who've read the TCPA, the statute itself, know that the statute refers to prior express consent as basically an exception for the automated calling provision. It doesn't actually say prior express written consent. That happened later in a 2012 FCC order, where the FCC determined that for certain types of calls, marketing calls in particular, that there was a need for kind of added requirements to prove that there was prior express written consent. Or prior express consent rather, right? So that's how we got the prior express written consent requirements that are in the regulations, okay? And what the FCC was looking at is, so what the FCC said with the one-to-one ruling is it added two more requirements that it believed were really just getting added to the definition of prior express written consent. The IMC court did not agree with that. The IMC court basically said, look, prior express consent as a concept is already defined by common law, and common law has construed prior express consent to mean like clear and unmistakable expression of a desire for something to occur, right? And by saying that for this to happen, and it can only happen on a one-to-one basis, or it can only happen in the manner in which things are logically and topically related to that consent, then you're saying that it's actually prior express consent plus, which is not allowed. So the idea is prior express consent already is defined by common law, and FCC, you don't get to say that like only certain types of prior express consent are valid. And so we revert to this world where the prior express written consent standard stays. Okay, you still have to get a signed written agreement that meets the certain disclosure requirements that are in existence under the regulations. But now there's this question of, okay, well, courts looking at whether your prior express written consent is valid may need to now consider whether or not the consent the consumers provided in that context clearly and unmistakably states what the consumer is looking to get in response. And to answer your question, Mike, directly, I think what that looks like is pretty similar to some things that we saw courts doing before the one-to-one consent rule went into effect, which is, where we see hyperlinks with lists of hundreds or thousands of entities, or we see consent language that is a little wishy-washy, or maybe like what you consider a generic kind of marketing consent, but it doesn't specify the types of calls or what the calls will be about exactly. Mm-hmm. That those types of things may not be clearly and unmistakably stated, or they might be hemmed in by context, which is what we already saw happening before.
That's great. Yeah. And Chris and Aaron, what are your thoughts? So we'll do Chris, then we'll go right to Aaron.
I think the big takeaway from this is going to be that, at least from the strategy that the FCC used to implement their whole logically and topically related one-to-one, that's not coming back. The court just struck that down. It's gone. That doesn't mean it couldn't come back through some other means, right? Congress, maybe a state legislature, something like that. But what Alexandra was really pining on there was they still say that consent has to be clearly and unmistakably stated. So there's going to be a lot of onus on, does your consent form, right, on that submission page where you're getting your TCPA consent, is that clearly and unmistakably stated? What does that look like? The courts are going to be deciding that, right? So this introduces some level of unknown into how, depending on what court you're in front of, what judge you're in front of, how they're going to interpret that. So you're going to want to be careful about how you're structuring your pages. So when you're doing your A/B testing or whatever, you really want to take into consideration, maybe I'm getting lift if my form looks this way, but maybe it's not so clear. Maybe they might have to scroll down a little too much to see my language, or maybe there's not enough indication that there's even language there at all. And you see certain cases in the last couple of years, like I think it was the Berman case with the hyperlinks, that courts are looking at, what does this language look like? And it's almost like they're using, like they're scoring a test, right? Where, you know, enough little notches against your disclosure and you're getting a failing grade, and it just invalidates it. So, you know, marketing companies in particular are really going to have to be careful about how they try and balance, you know, impacts on conversions with how the page would actually look from the perspective of like a judge if it's called into question.
I want to put a finer point on that too. The clear and conspicuous disclosure requirements for prior express written consent are still in effect. So you still must clearly and conspicuously disclose to the consumer that they are agreeing to receive automated marketing calls and texts, right? And that their consent is not a condition of any purchase or access to services. That has to be there, and it must be clearly and conspicuously placed on your form. So, you know, what Chris is also pointing out is there's probably there will be like a scope issue as well, kind of like, does your consent say what you say it says, right? And that's going to be the ultimate caller's job to prove. And that's what courts are going to be assessing.
Yeah, and just to add to that, your name still needs to be there. I think a lot of people are like, oh, well, one-to-one's gone, you know, I don't have to worry about this so much. But your name still has to be present, that they're giving consent to you. It doesn't have to be one-to-one anymore. There can be other names, but you still have to be there. And I think it's good to go back and think about why the FCC introduced this rule in the first place. You know, what are the problems they're trying to solve? Because those problems still exist, right? They're trying to close the lead generator loophole. FTC is trying to get rid of the consent farms, what they call consent farms. And a lot of it comes back to this hyperlinked marketing partner list that lists, you know, hundreds or thousands of companies. I think that's an area that they're going to be looking at.
I think it's also worth considering what the 11th Circuit was actually looking at, right? IMC presented some examples that were very clear. Okay. And they are not akin to a lot of what we see in the lead gen context. And so I don't want anyone taking this as, you know, an opening or a free for all to just kind of go back to this idea that Steve was discussing, which is, you know, we can still have 5,000 names in our marketing partners list, and they could be unrelated to the page where we are collecting consent. I don't think that's really where we're going to end up when we get through these court rulings that flow from this IMC decision.
Aaron, do you want to go?
Yeah, I just think we got to tread lightly, you know, the concerns that have been raised here until we figure out what clearly and unmistakably implies. I feel like for a good amount of cases challenging consent, it was the question of, well, did I fill this lead form out? Can you prove that I actually filled it out? Now we may see a shift into whether there's a defect in the lead form, which might actually make it easier to establish a class, which you know, we're all aware of the bet the case, how quickly a class action can become a bet the company case. So it's no longer did I, but is it is there a defect? Is this legal? And when we're talking about clearly and unmistakably, I think that it kind of draws attention that it can leave no room for ambiguity. It has to be clear and conspicuous. It has to be seen and understood by the consumer. It should be separated from other parts of the consents that we're getting. We shouldn't bundle it with consent to data disclosing or anything in our privacy policy. And it shouldn't be buried in a lengthy document. Just some of those general, clear, and conspicuous standards that have already been established. And what might be helpful for some is to take a look at the FTC's.com disclosures. They talk a lot about how we have to present disclosures to consumers, and they do provide a pathway where we can link out disclosures. So when we're talking about this, can we use a hyperlinked marketing partners list? Based on the way you read the .com disclosures, that avenue is completely within the bounds of that, because if we take certain steps to direct the consumer to the disclosures that are behind the hyperlink or that are in a different spot, then it may be that the consumer should be aware of those disclosures.
Yeah, and Aaron, I think it's such an excellent point. All of you guys have provided some great input on this topic. And I think something that I believe is important when it comes to the TCPA is that you should always be monitoring your disclosures, right? There's obviously components of the design of the page, the placement of the disclosures is important. Obviously if it's buried down at the bottom in light gray font, that's going to be a problem. But, you realize that if you are, especially if you're purchasing leads, that you need to know exactly what those disclosures are saying and what that customer is agreeing to across your different vendors' landing pages. Because if you get into a TCPA class action, that's going to be something that's going to be a part of the discovery process. They're going to pull those disclosures. They're going to ask questions on them. And if that language is ambiguous or extremely unclear, you could actually end up getting into a lot of trouble. Aaron, one thing I'd like to hear from you and the rest of the panelists on here was in the 11th Circuit Court's opinion, they mentioned a lot about, really how the FCC had really overstepped their bounds. And they basically said that it was the FCC through their rule was basically doing prior express written consent plus additional restrictions. And the plus was really the problem. Can you talk a little bit more about that and just kind of break it down for our audience?
Yeah. And Alexandra kind of hit on this when she said that the TCPA explicitly requires prior express consent. The Congress did not define that in the TCPA. So the court deemed that to mean that Congress intended that common law principles apply, which is where we got the clearly and unmistakably standard that we've just been discussing. Mm-hmm. So with that being said, they took that common law principle and said, well, wait a minute. Now we're adding that it can only be one seller at a time. Now we're adding that it has to be logically and topically associated with the interaction. Well, I think the IMC brilliantly argued that this was essentially operating to take away the consumer's statutory right to consent to the calls they want to receive. I think that is true. It's not so much that the consumer might have been confused or what, but it was that by requiring one-to-one and logically and topically associated, there were instances that the IMC pointed out where that actually operated to not allow the consumers to consent to what they wanted to hear about.
Great. Aaron, I appreciate you breaking that down for us. So we actually have our next poll here, and this is actually for our various publishers. So if you are a lead generator or a publisher, do you plan to revert back your forms to the hyperlinked list of marketing partners in your disclosures? Yes or no? I'll just give you a few seconds there, and then we're going to move on to our next topics. All right, it's coming in here. Give it a few more seconds. Wow, this is actually fairly interesting. We see almost an even 50-50 split, which to me I think is interesting. I actually anticipated there'd be a little bit higher on the yes side, given the way that the ruling went. But I think over time, as we start seeing these courts go through and issue their opinions on the disclosures and how the consumer provided consent, this may change, but that is a very interesting result. Okay, our next question here, Chris, this one's actually specific to you. So we've had a couple of comments actually on this as well. There was a CMS rule last year related to TPMOs and data sharing. That particular rule referenced the one-to-one consent rule from the FCC. Can you talk a little bit more about that and just kind of break down, if the FCC's rule was vacated and it's gone, does that still apply to the CMS rule?
Yes, the god-awful CMS rule. So the FCC's one-to-one getting shot down has really no bearing on CMS's one-to-one rule. And the reason why, and I get why it's hard for people to wrap their head around that, because CMS explicitly pointed to the FCC's one-to-one rule when making their rule. But these are under two different statutory frameworks, right? The FCC's one-to-one rule stems from the TCPA, which, they're granted power over, right? But they're handcuffed by what the statute says that they can do. The statute said that they can implement the TCPA, right? They can create regs to implement the TCPA. Well, in that regard, the 11th Circuit basically said, hey, you're given the power to implement the TCPA, not to rewrite it, right? Which is essentially what they were trying to do. They were trying to rewrite the statutory language that basically definition of prior express consent. That is totally different from CMS, where they're implementing their rules based off of a totally different statute to get to a totally different outcome. The CMS was concerned about data sharing, right? Sharing of beneficiary data between TPMOs. All they did was they said, hey, we like the mechanism that you're using, the scaffolding for getting consent. We just want to borrow that, right? The 11th Circuit didn't say that there was anything wrong with the scaffolding. They just said that the FCC in particular did not have the authority to implement that, right? So they're totally unrelated.
So just to kind of clarify here, you're saying that basically the CMS used the FCC's one-to-one consent as like the framework for how they built their rule, and
right.
Any business entities that are covered under the rules and regulations of the CMS actually do have to do one-to-one consent. Is that
correct?
accurate?
Yeah, one-to-one consent is still effective in Medicare. The FCC ruling has no bearing on it whatsoever. Now, to be fair, the one-to-one rule for CMS is being challenged in a court right now. However, it's being challenged for other reasons, right? Where IMC was challenging the FCC's rule saying, hey, you didn't have the authority to do this. The challenge to CMS's one-to-one rule saying, hey, you didn't jump through the proper hoops to implement this rule. You didn't do a proper analysis. You didn't actually show that this rule was necessary and that you took in all the relevant factors.
Got it.
And I think this is a broader trend where regulators are tightening consent and revocation requirements across various sectors. Last year the FTC amended their negative option rule that governs subscriptions and like reoccurring billing practices. They require businesses now to provide a one-click cancellation to make it easier for consumers to cancel subscriptions. In the privacy realm, state laws are increasingly focusing on consent requirements. Several states have heightened consent requirements to collect certain types of personal information or to do certain types of processing activities. There's other state privacy laws that regulate very specific sectors, like the state health data privacy laws that impose stringent consent and disclosure rules. So I think we are in the midst of a complex regulatory environment where we're seeing this tightening of consent and revocation.
Yeah, and I personally, I absolutely agree with you on that one, Aaron. We've seen, if you look at like the spirit of these different regulatory agencies, and even you've got some state legislatures who are starting to pass laws that are related to consent, data privacy. It's only going to get more restrictive. And really what they're trying to do is protect consumers' data, make sure that the consumer understands who they are consenting to contact them and do business with, and then all of that is clearly disclosed to the consumer within the various forms that they are entering in their information. And obviously their data is protected through that whole process. All right, we're going to move on to our... Second. Oh, yeah, go ahead, Chris.
Right, just don't mean to interrupt.
Chris and Alexander, if you've got something.
I just want to make sure that this is unmistakably clear. But I guess before I get to that, this is not legal advice. I'm not your lawyer. I'm Apollo's lawyer. Go to your own lawyer. That being said, just so it's unmistakably clear, one-to-one consent is still active in Medicare. That did not go anywhere. You still need one-to-one consent. Caveat is the one-to-one consent in Medicare is in relation to data transfer of beneficiary information between TPMOs. Okay? It doesn't have to do necessarily with calling. So if you're a marketer and you're doing your own calling and you're not sharing data, you don't necessarily need one-to-one consent for Medicare unless you're going to be sharing that data with another TPMO. So again, different rules, but one-to-one Medicare is still in effect.
Okay. All right. So let's move to our last poll here. We just kind of get an understanding from our audience. Do you currently monitor your lead disclosure language today? Just give you a few seconds to fill that out, then we'll move into our next set of questions here. All right. Just give it a couple more seconds. Okay. Yeah, so it looks like actually a decent amount of you, which is good. We do see a good amount of our audience, almost 83%, are actually currently monitoring their lead disclosures across their vendors. We've got 5% with no, and then we've got 10% that are also no, and they would like to hear a little bit more about solutions for that. This one is a little surprising. It's a lot higher than I had anticipated it to be, but obviously it's great. If you are over there, you should be monitoring your lead disclosures. We've talked about it at length here in our webinar series, and you really should be doing that as a best practice. All right, let's move on to our next question. There is on April 11th, there's a consent revocation rule that's coming through where basically consumers, if they revoke their consent on a text message or a phone number, a text message or a phone call, it applies to really all channels. Does the FCC's one-to-one consent rule being vacated affect that rule in any way? Chris, Alex, anybody?
So I'll jump out here first. The short answer is no. The FCC's revocation rules that are, number one, some of them are already in effect, and the rest that go into effect in April will still go into effect. Practically speaking, that order is very broad. The regulations construction of revocation is very broad. In fact, broader than even maybe the scope of consent that you're obtaining. Okay. So, basically what that ruling says is you are required to recognize consumers' attempts at revocation as long as they're reasonable. The FCC's deemed certain methods to be reasonable, so you definitely need to be recognizing those, and you need to be applying revocations broadly across like all channels, all programs, and all types of calls and texts, okay, that are regulated. And if you want to narrow that revocation in some way, you have to utilize the tools that are available to you, like a confirmatory clarifying message, which the FCC has approved, to clarify the scope of that revocation. Kind of longer term, what does that really look like? To me, I almost feel like that FCC ruling and kind of the ultimate impacts are maybe even more significant, honestly, than this one-to-one consent rule. And it's really been overshadowed. So if you haven't had a look at that ruling and you don't yet have processes in place to comply, that is something you definitely need to turn your attention to, because those things are right around the corner. And some of them are already in effect.
Yeah, and as Alexandra mentioned, they're pretty broad. I mean, for example, the FCC stated that a request made via voicemail or email to a non-designated opt-out number or address creates a rebuttable presumption that consent was revoked if the consumer can reasonably expect to reach the business. Now, the FCC and courts will evaluate these opt-out methods and whether the consumer could have reasonably expected to reach the business based on a totality of the circumstances. In the legal world, those totality of the circumstances factor shifts can kind of be painful, and they're not always as intuitive as you think they might be.
Great. Thank you guys for answering that. Christy, if you got anything, great. If not, we can move on to the next part.
Nope.
Okay.
Nothing for me.
All right. All right. Last item here. So we have had a couple comments and questions on this. So do we anticipate the one-to-one consent rule to come back sometime in the near future and maybe in just a different format? And what do you guys think will happen in the next couple of years related to consent?
I think it's possible, but it wouldn't come from the FCC most likely. You could either see Congress amending the TCPA to give an actual definition to prior express consent. You could see state legislatures trying to implement under their telemarketing rules one-to-one consent. It's one of those things where there's a lot of avenues for this to try and be reintroduced. It's just the 11th Circuit shut this one door, right? They say, hey, FCC, you can't redefine prior express consent. You don't have the authority to do that. But again, Congress could just potentially give them the authority, right? We've seen amendments introduced to the TCPA, in previous congressional sessions. They didn't get any traction. They didn't pass. But there are individuals out there who are motivated to, I would say, broaden and expand the reach of the TCPA. So it's something you should always be aware of and have in the back of your mind.
I think that at least initially, the most of this will be coming from courts that are seeking to kind of figure out exactly what prior express written consent is okay, which they have been doing previous, right? And I think that will continue. We already saw kind of a foreshadowing to logically and topically related in how courts were construing kind of unspecific consent language. And so I think that will continue. Absolutely. I think we'll see courts looking at whether a consumer can reasonably expect that they're giving consent to certain entities by the way that the disclosure has been presented. I also want to come back to something that Chris, you mentioned before we even got on stage, which is, maybe the FCC might be able to introduce this in a way that is a little bit different than what they did. Do you want to talk about that?
Yeah. So one thing I could see, if it's hard to say with this new administration and having, a new committee heading the FCC, it's hard to say if they cared that much to move forward with this. But one way that they could potentially go about tightening up prior express consent is, instead of trying to redefine what prior express consent is, saying that it has to be one-to-one or it has to be logically and topically related, they can say, okay, here's what we consider to be, clear and unmistakable, right? And they could say something along the lines of, just hypothetically, you need to tell in your disclosure, so that it's clear, how many parties are going to call the consumer, or up to how many parties could call the consumer, right? So your consent language would possibly say, I provide my prior express consent to be contacted by up to 5 parties, right? And that way, they're not limiting you, potentially saying like, oh, you can only pick this one party at a time, or you can only pick so many parties. They're really just saying like, hey, here's what clear and unmistakable looks like, right? The courts may be more open to that because it's kind of along the avenues of here's what consumer expectation, right? Rather than restricting the consumer to what they agree to, they can agree to 100 parties, they could agree to 5, they could agree to 1,000, but you just have to make clear how many parties they're potentially agreeing to.
What I imagined, if they were to do that, that would go kind of in their list of what your clear and conspicuous disclosures would need to say. Yeah. And honestly, that's really kind of the neat trick. And I know Aaron had mentioned this too, with the IMC presentation of this argument to the 11th Circuit, right? The IMC took, a couple of specific examples where very clearly the consumer wanted to do something that basically wouldn't be permitted under the FCC's ruling and new regulations. And so, it was that presentation that made it seem like prior express consent plus, when really it could very easily have been the opposite, right? Like you're not saying a consumer couldn't do it that way. You're just saying that it needs to be clear, right? And I think that's what Chris is, hypothesizing of possible options if the FCC were to do something like revisit this. That might be how they approach it, because that is the lesson that this IMC ruling has really shown.
Now, do you think, Alexandra, or really any of the panelists here, we have a question here that kind of relates to this. It actually got 23 votes. It's the highest votes I've actually ever seen for a question. And what it's asking is, based on the outcome of the 11th Circuit Court decision, should the consent language be above the submit button so that way it's clear and unmistakably, that the consumer is clearly and unmistakably providing their consent?
So this issue is not I want people to think about it like this. This clear and unmistakable standard is kind of like a high level standard that exists for like, is this prior express consent? Okay. But in order to have prior express consent for marketing, you still need prior express written consent that satisfies the requirements in the regulations. Nobody has overturned that. That is still a requirement. And so the issue that we saw before, and the issue we will see again, is whether or not below the button disclosures are clear and conspicuous, so that you are making the clear and conspicuous disclosure requirements that are required for prior express written consent. And that's not going away. And kind of the way we've seen courts break on that is mixed. And, it really depends on a lot of other things. This totality of the circumstances kind of approach, the context in which you're presenting, that still exists, right? And there's lots of questions that courts look at when they say, is a below the button disclosure clear and conspicuous? Because you still have to have a clear and conspicuous disclosure. And the issue there is, maybe depends on, is your form all being presented on one page, no matter what device you're viewing it? Could that be displayed below the fold? How much space is between your button and that disclosure? What color is your disclosure? Does your disclosure kind of include a bunch of additional stuff before it really gets to the meat of the issue? Could a consumer miss it? And what we find is generally courts disfavor below the button disclosures. They are much, much, much more likely to uphold above the button disclosures. And so that is always best practice. Now, if you're in a situation where you're considering putting a below the button disclosure or permitting it to persist, you really need to visit kind of the holistic look at that page and say, is this clear and conspicuous? Because that's what a court's going to do.
Yeah.
And there's some ways that we can bolster that. I mean, I think referring back to those FTC.com disclosures, if we're directing the consumer to the disclosures made below the button, I think that kind of bolsters the position that those are maybe compliant. So as Alexandra hit, generally we want them above the button, as courts favor that. We don't want them in some fine print or in a footnote. Those are typically insufficient. We want them to be seen and understood by reasonable consumers. And look, that just promotes transparency and trust. We're telling the consumer straightforward. They see it. They get an opportunity to make their decision. So just kind of taking a step back and thinking, if you're the consumer in this case, what would you want to see on there?
And to put a finer point on it, I mean, Aaron's right. We can look at situations and kind of with your counsel, you can examine whether certain things are permissible based on how they're presented, but also be thinking, if I had to defend this in court, right? What would I be telling? What would my story be? How would I establish that this is clear and conspicuous and that the consumer understood it and agreed? And the position you're in when you have an above the button disclosure that's very clear versus the position you're in when you have a below the button disclosure that maybe isn't as clear or available to the consumer is very different. In fact, it's so different that it's the difference between maybe getting a walk away from the other side versus having to stick it out and fight it through and, summary judgment or beyond. And so, those are also factors, right? If you have a very strong disclosure and it's very clearly presented, you are in a much better position to say, look, as long as that person really was the person who agreed, which is a whole other issue, the consent's good here. And so you really don't have a basis for your claim.
Just to add to this, Mike, these gray areas are all just factors of risk, right? And how much risk are you willing to take on? Do you want that disclosure above the button or you want it below the button? So Alexandra's point, you're in a less risky position if that disclosure is above the button. Now, you talk to a lot of lead providers out there, and you say, hey, I want my disclosure above the button. They're going to probably give you some pushback because they're like, that's going to hurt my conversion rates. So then you might have to pay a little bit more to get that sort of structure. And so then, you're certainly always balancing this sort of risk versus, how much do you want to pay per lead? And you need to be willing to pay, in my opinion, pay a little bit more for higher quality and more compliance. And back to the poll earlier about, are you monitoring this stuff? This is why it's really important that you monitor this stuff. You got to pay attention, see what the providers are doing, and have an open dialogue with them about what you need as a buyer and what your level of comfort is.
Yeah, and that's a great point, right? The one-to-one consent rule encouraged a lot of people to visit whether their vendor contracts and their disclosures required reviews, or vendor contracts maybe needed language that they didn't have. Don't miss the opportunity to do that if you haven't done it, right? Just because the one-to-one consent rule is gone doesn't mean that those things are not important. They still are, as all of us have indicated. And so, making sure that you're getting what you need from your partners and that you have addressed those issues in the contract to your, liking and specification, and that you are conducting the reviews that you need to ensure that your consents are good. Those are all still best practices. They're all still things you should be doing.
Yeah, absolutely. Especially when it comes to updating vendor contracts. I mean, I know a lot of people on this in the chat right now probably sent out amendments for one-to-one, right? You probably need to go back and look at, do I need to terminate this amendment? Because it may be requiring you to submit a traffic within a narrow confines that you're not going to be complying with anymore, right? But you also need to consider, if you terminate that, were there other compliance provisions in there that you maybe need to reincorporate in a new amendment, right? Because I know there's probably people in the industry that signed an MSA 3 or 4 years ago, right? And you use this one-to-one as an excuse to tighten up that MSA. So it's especially for legal departments, I think it's really important that you go in and you reassess all these vendor agreements.
Yeah, I couldn't agree more with that, Chris, because one of the things that I think was a really big benefit of the FCC's one-to-one consent is that really we've started to see a lot more collaboration, not just amongst like the different publishers within the ecosystem. You've got the Reach, you've got IMC and things like that, but we've also seen collaboration between the lead buyers and the publishers and working together to provide compliant forms and disclosures and talk about contracts and pricing. And I feel like before the one-to-one consent rule came in, it just wasn't as common as it used to be. A lot of people, they'd just get an MSA from a provider, they'd sign in, they'd be done. Now they talk to each other on a regular basis. They're going through and reviewing these lead forms, making sure they understand the consumer's experience. And really, I used to buy leads. I bought 2,500 leads on a daily basis. I wanted to make sure that I knew exactly what that consumer was going through on that lead form. I wanted to know what they saw. I wanted to make sure I had a record of that process. And I wanted to make sure that my contracts explicitly stated what records I had access to and what I had and what data I had rights to discover from my publisher. And so I think it's a great point. Steve, sorry, Chris, do you want to say something?
I was going to say, one case in point that you saw people really focusing on was also part of this rule was the record keeping requirement, right? Yeah. Saying that the end seller that's doing the call needs to keep records of their consent. So you saw a lot of updates to contracts that normally were kind of silent on how that consent needs to be required, needs to be kept, putting in requirements like, hey, you need to have active prospects trusted form, right? We're not going to buy leads that don't have it. So again, if you're going to be terminating your amendment, you need to make sure, is that still important to you? It absolutely should be.
Yes.
That you at least incorporate that into another amendment to have that required. Because, and to be clear, yes, those record keeping rules under this specific order of the FCC were also vacated. However, the FTC has their own record keeping requirements under the TSR that require like the same exact records to be kept.
I think also it's not quite like, it is true. The record keeping ruling was within that section that was vacated, but the FCC in issuing that paragraph, right, they said, this is just affirming what is already required. And so, I don't think for any of us, we all know the 2015 omnibus and previous confirm that it is the caller's duty and obligation to prove that they have consent, right? And so you do need to have records of that consent. So that is not a shock, and that shouldn't be a shock. You have always needed to, and you do need to have record of the consent that you're relying on to make your calls.
Yeah.
All right. Last thing here. So this one is for you, Steve. So I'd like for you to, you recently actually wrote about this on LinkedIn. You talked a little bit about the FCC's ruling and, really what is like the path forward for lead generators and lead buyers. Can you just close things out here, talk a little bit more about your experience and just provide some more context to our audience?
Yeah, sure. I don't know about you guys, but I feel a little bit like I felt after the COVID pandemic, where it's like, I'm kind of glad it's over, but I feel like I lost a year of my life. And I think that's how a lot of people feel. A lot of the lead generators, they spent all this time working over the last year. We talk about one-to-one consent all year long. And then all of a sudden it's like, oh, it's gone, never mind. And so I just want to encourage folks to say, don't feel like that work is in vain, right? I think the industry did a phenomenal job working on changing the workflows for the consumers. And, I look at it, I think everyone generally agrees that one-to-one consent is a good thing for consumers, right? I think everyone, as a consumer, everyone wants to have better control over who contacts them and who gets their data. So from a consumer perspective, it's a good thing. And from an advertiser perspective, from a lead buyer, hey, I'd much prefer to get a one-to-one consent lead versus one that's not, right? Someone who's explicitly given consent for my brand to contact them, great. That's the best. That is a high quality lead. I think the challenge gets into the lead providers, right? The business model challenges, like can you charge enough per lead to make it work, right? And I think that's where, and it's technically a lot harder to do, quite frankly, right? And that's where people have done a great job working on that. And so even though the rule is gone, I hope we can still move forward with this as a best practice. And for that to happen, ultimately, the buyers have to pay more for quality. You got to pay more per lead to get that higher quality lead. I think it's a better experience. And for you and for the consumer.
Yeah, absolutely. There's some real economic realities in their discussions that would have to have between the lead providers and the buyers, because I mean, it's not just the price of the lead, right? It's also rejections, returns, and then if you have X amount of buyers, who are you going to list on the form, right? What kind of criteria are you going to have for that? And that was something that I don't even think anyone really fully worked out. We were just going to hope that it worked out over the next
there was
years.
Still a lot to be worked out.
Yeah. So, from a consumer perspective, it sounds great, but you also have to deal with the reality of, people, they say they want choice, but when you give them choice, they freeze up, right? Analysis paralysis.
Yep.
And it can be off-putting for people when they're given even 6 names and they're like, I know State Farm, but I don't know agent B or C.
Right.
I guess I'll just go with what I know, even if State Farm wouldn't even give them the best opportunity. So there's I agree with you. It'd be great if it was a best practice, but I think it really comes down to the lead provider and the buyers and how they can make their business model sync up to actually make that work.
Yep. Absolutely. And one other thing I just wanted to add is that the TCPA is still in full effect, and this is not a time to let down your guard. You still have to be vigilant. I've heard some people, and there's some questions about this in the chat. They're like, hey, do I still need to use Trusted Form Verify? It's like, well, yes, Trusted Form Verify is there to verify that you have consent under the guidelines of the TCPA. Whether or not one-to-one is one of those guidelines, you still need to make sure you have consent. Make sure your disclosure language is there. Make sure your name is there. All this is clear and conspicuous. All that is still in effect. So it's still important to pay attention to that.
Absolutely. To be clear, the plaintiffs bar, the plaintiffs attorneys are highly motivated. There's a lot of money in this, okay? They're probably disheartened that one-to-one didn't go into effect because that was creating more checkboxes for you, more technical implementation. And they were probably salivating at the thought of someone screwed up in their implementation and they can nickel and dime you here and there to get big payouts. They're clever. They're still just going to, okay, fine, I'm going to find a way to invalidate the consent you already have, the methodology that you're already using, right? Get to the point of litigating in court. They're going to be bringing every argument they can. The consent was under the fold. The font was didn't contrast enough. The hyperlinks didn't contrast enough. One big thing, you got to make sure you're checking your partners list if you're using a hyperlink. Don't just trust that your account managers are properly adding names to it.
Yeah. Well, and Chris, I think that's an interesting point because I actually had something like that happen myself where, we were given the partner list and we realized that, it was a list of about 400 lenders were on that list. Our company was at the very bottom of that list. And, that raised a lot of questions from our compliance department, which is like, well, if they click on the list, hundreds and hundreds of entities, if you're all the way down at the bottom, is that consumer, do they understand like, hey, they're consenting to you? And it's just important that you have to vet what your providers are doing. And look, you can have an open conversation with them. You're like, look, I need to be able to see what these consumers are going through. I want to make sure that you're using technologies like Trusted Form so you're capturing that consent. And, look, publishers are used to this now. This isn't something that's foreign to them. A lot of them have gotten more comfortable with this, especially with the one-to-one consent rule, and have that open dialogue. And if there is a certain form that you're not comfortable with or lead funnel that you're not comfortable with, talk to them about alternative products. They may have products that are exclusive leads or transfers, whatever it may be, that they can offer you if you are not comfortable with one that has higher risk involved. And I think it's just important to have that kind of dialogue and treat each other as partners, because look, in the long run, we're all here to make money. It's no secret. the lead generators want to make it, and the people who are buying it. They're trying to sell goods and services to those leads. So have that dialogue and move forward. So anyways, we are at the top of the hour. So I appreciate, like I said, this was an excellent discussion. I feel like we covered quite a bit here in relation to the FCC order being vacated by the 11th Circuit. And, I'd like to thank all of our panelists on here. Thank you so much for covering everything. And everybody here, you have a good day. Okay. Thank you all for coming.
Thank you, Mike.
Thank you.